All right, today we're jumping right into a really fascinating legal showdown, and this one's happening right in a local homeowners association. It's a wild story about rules, how you read them, and what happens when someone fights for the right to run for office in their very own neighborhood. So just imagine this for a second. You've served on your community board, maybe you were even the president. You decide you want to run again, but the very board you used to lead turns around and tells you, nope, sorry, you're not allowed. I mean, can you imagine? That is exactly what happened in the story we're breaking down today.
Okay, so let's set the stage. On one side, you've got our petitioner, Sharon Maiden. She's a homeowner, she's a former board president. And on the other side, the Val Vista Lakes Community Association. Yep, this is a classic showdown, an individual taking on the very organization she once headed up.
And you know what's so wild about this? This whole huge dispute, it all boils down to just a handful of words. I'm not kidding. The entire legal case, all the lawyers, the testimony, it all comes back to how you interpret one single sentence in the community's bylaws.
And here it is. This is the sentence that caused all the trouble. Commencing with the first annual meeting after the adoption of these amended and restated bylaws. See? Everything hinges on those first two words, commencing with. What does that actually mean here? You might think it's simple, but oh boy, as we're about to see, it is anything but.
Okay, so this whole fight really gets down to a big legal idea, prospective versus retroactive. Let's break that down. Prospective is Maiden's side. It basically means the new rules only apply from this point forward. It's a fresh start, right? The clock on term limits resets for everybody. But the retroactive view, that's the HOA side, means the new rules look backwards. Your past years of service, oh yeah, they still count against the new limit. Two totally different ways of looking at the same rule.
So let's look at Maiden's case first. How did she and her lawyers build their argument? Well, it was actually pretty straightforward. They said the 2021 bylaws were a complete and total rewrite, a brand new playbook. And if it's a new playbook, then everyone should start back at page 1.
Her argument really stood on four main legs. First, she brought in witnesses who said these new bylaws weren't just a tiny edit, they were a whole new package, a complete overhaul. Second, she argued that the plain language, commencing with, is obvious. It means starting now. Third, she had not one but two different legal opinions from the past that supported her going forward interpretation. And finally, and this is a huge point, the HOA itself had literally just let another former president, a guy named Bill Sutel, run for the board in 2023 using what seems like the exact same logic. Kind of looks like a precedent, right?
In this quote right here, from Bill Sutel, the former president who actually helped write the new rules, this really gets to the core of her case. He testified under oath, "I believe the intent was that the beginning date reset the clock for everybody." Wow. I mean, that's a pretty powerful statement from a guy who was literally in the room where it happened.
But, there are always two sides to a story. The HOA's counter-argument was really interesting. They didn't focus on the exact words as much as the intent behind them, the spirit of the law, right? They basically said, hey, the whole reason we changed this rule was to stop people from serving on the board forever.
So the HOA's case was all about intent. They said, look, our goal was to shorten terms, but Maiden's fresh start idea, it actually creates this crazy loophole. A director could serve, say 4 years under the old rules, and then if the clock resets, they could serve another 4 under the new ones. That's an 8-year term. That's the exact opposite of what we wanted to achieve. They also pointed out that the bylaw committee never, not once, discussed grandfathering anyone in. And then they dropped a bombshell, a piece of evidence that completely targeted Maiden's key witness.
So remember Bill Sutel, the key witness for Maiden, the guy who testified that the intent was to reset the clock for everybody? Well, the HOA's lawyer had a pretty simple but devastating question. What did you yourself write to the whole community in your farewell message just 2 years ago?
Bam! There it was, in black and white, from Sutel's own newsletter back in November 2022. He wrote, "This will be my last president's message, as my term limit of 4 years is up." This totally contradicted what he said on the stand. It basically showed that at the time, he absolutely believed his past service counted and that he was termed out. I mean, you can imagine, this was a massive blow to Maiden's case.
Okay, but the term limit fight wasn't the only thing going on here. There was a whole second part to this dispute. Maiden also filed a complaint about how the board voted to disqualify her in the first place. She claimed they did it in a secret, illegal meeting, which is a big no-no under Arizona's open meeting law.
So here's how that argument broke down. On one hand, Maiden's side claimed the board violated the open meeting law. The meeting wasn't properly announced, and they went behind closed doors for no good reason. But the HOA defended itself, saying, whoa, hold on, it was a totally valid executive session. They argued they had a legal exception to be in private because they were discussing advice from their attorney and what they called pending or contemplated litigation.
Now, to really get this, you got to understand a little bit about Arizona's open meeting law. The main rule is simple. Board meetings have to be open to the public, period. But, and this is a big but, there are a few very specific exceptions. A board is allowed to meet in private to get legal advice from their lawyer or to talk about a lawsuit that's either happening or about to happen. The HOA's whole argument was that their meeting fit perfectly into those exceptions, since they were talking about the legal side of Maiden's eligibility and, well, she had already threatened to sue.
So, after all the back and forth, all the testimony, the conflicting evidence, the whole thing landed in front of an administrative law judge for the final word. So, let's get to the verdict. How did it all shake out?
Okay, first ruling, the term limits. The judge ruled in favor of the HOA. And the reason came down to one thing: intent. The judge looked at it and said the whole purpose of the 2021 rule change was to prevent long terms. The judge concluded that Maiden's interpretation would create a loophole for people to serve 6, 8, even 10 years, which completely goes against the clear goal of the bylaw.
And what about the second issue, the closed-door meeting? Well, on that one, the judge also sided with the HOA. The ruling found that the board met in that executive session to go over a legal opinion from their lawyer about the whole situation. And since that is a specifically permitted exception under Arizona law, the meeting was totally legal. No violation.
So the final decision was a complete victory for the Val Vista Lakes Community Association. Sharon Maiden's petition was denied across the board. The judge found that the HOA's actions were in compliance not just with its own bylaws, but with state law as well.
And this whole story really brings us to a huge classic question, one that lawyers and judges have debated forever. When the rules are written down one way, the letter of the law, but the intent behind them seems to point in another direction, the spirit of the law, which one should win? In this case, the judge sided with the spirit, but it really makes you think, doesn't it? What would you have decided?